And I am very thankful that I have been allowed this opportunity to remain present with so many learned professionals, and I see it as a privilege on my part. Now, directly coming to the topic for which we have associated. So, it is about SEBI proceedings. Now, when we say SEBI proceedings, these are divided broadly into three categories when it comes to independent proceedings being carried out by SEBI under SEBI Act. Then there are individual acts as well, like intermediary regulations, where actions are taken against intermediaries and all. But generally, what would be applicable to either the listed companies or the common public at large would be the Section 11 proceedings of SEBI, where the whole-time members used to take action. Now those powers have been delegated because there are a lot of matters. So even the executive directors and chief general managers have been bestowed the power to deal with the Section 11 proceedings of SEBI. Second is the adjudication proceeding under adjudication rules. I will first give the brief of all three proceedings which are there, then what it is covering. So then one is the under adjudication rules and regulations, where a adjudicating officer is appointed to adjudicate, one, whether there is a violation or not. Second, whether there is any graveness in the violation that warrants a penalty or not. And if it is so, how much amount of penalty should be levied. Now, this session, what we will do is, if required, some of them can even make notes, because see, there will be some critical sections and case laws that I would be discussing, which will be helpful in allowing you to offer services to your clients. See, the goal of today's seminar should be that when we move out from here, all of us have a reasonable capability and understanding of the SEBI proceedings, so that if need be, we are able to directly service our clients. It need not come to me. If that is achieved, I will think my purpose is served. If it comes to me, I believe then I have not done justice to the entire act or responsibility that has been bestowed upon me. So please make notes of relevant things that will be very helpful to you. We have just discussed Section 11. Please note that. So Section 11 is a proceeding where CGMs, EDs, and whole-time members of SEBI would look into the matter, check the merits, find whether a person is guilty or otherwise, or has violated any of these sections of SEBI Act or any regulations, and then recommend actions. Earlier, the action recommendation was limited to either warning or debarring a person or suspending a person for a limited period of time. Both debarment and suspension is for a limited period of time. But then the powers, what was happening is, at times some matters are such where monetary penalty is also to be levied, and some department is also to be given. So there SEBI was constrained to take both actions. One is adjudication, and second is the 11th section proceedings. So those powers have also been bestowed upon the person looking into the matter under Section 11. And now both, including debarment, monetary penalties also can be levied by the same person who is looking into the matter for Section 11. So therefore, it is avoiding double proceedings, and it is avoiding choking up of the SEBI infrastructure of adjudication and regulation of the markets at large. Now comes the adjudication proceedings, where we have seen that there would be an adjudicating officer, and he will adjudicate whether there is a violation. If yes, then whether it warrants a penalty. If yes, then what amount of penalty is to be levied. Next comes is the Section 24 proceedings, which is the prosecution. Now, this is generally not resorted to by SEBI only once in a maybe 500 or 1,000 cases, where there is a large scale impact on the common investor. SEBI goes ahead with proceedings of prosecution under Section 24. Now, these are broadly the three kinds of proceedings that all of us generally come across. Apart from that, there are, I told you, specific regulations like the intermediary regulations. So any intermediary who is registered with SEBI, that person will be proceeded for violations under intermediaries regulation. Right now, having broadly understood what are the sections under which proceedings have can be initiated, let us go into the practical aspects as to how things are actually done at SEBI level. So first is that whenever there is a reason to investigate, see, SEBI constantly monitors whatever happens in the markets. It has its own softwares and its own source of information where investigations are carried out. Second is it also acts on the complaints that SEBI receives, because there may be some whistleblowers in entities, or there may be some other people who have suffered who may prefer to have a complaint to SEBI, or there may be any other person who is interested in complaining against something happening wrong. They may complain, and then SEBI checks into the merits and carries out an investigation. Now, when investigation is carried out, it is carried out by a person called designated authority. Now, you can write down all these technical terms because those are helpful when you discuss with the clients also. So, the designated authority performs the investigation. Once the investigation is performed, that investigating officer, based on his assessment of the entire situation, will decide on one, whether there is any mischief or violation of SEBI regulation. Second is, if at all it is so, then what kind of proceeding is required to be initiated. So the least amount of least grave proceeding that you can say is the general adjudication proceeding, where there is only monetary penalty. See, for some people who are actually not very much connected in the market, for them Section 11 may be a lesser grave penalty. Okay, a ban of 5 years, it does not matter, I will not trade. But SEBI does not see it that way. See, a ban is seen much more severely than a monetary penalty. So the smallest of action is recommending adjudication by the designated authority. Once the second grave recommendation would be Section 11 proceeding, which includes monetary as well as non-monetary penalty like debarment or suspension for a particular period or some other restraints that SEBI may choose to do. Third is the prosecution proceedings that the designated authority may recommend. Now, how does the investigation get carried out? See, based on whatever trigger, see, the place from where the investigation initiates is a trigger. It may be internal, external, complaint, whatever. Once that is triggered, the designated authority is under a responsibility to do a just and fair job. So they will also investigate and seek details from the persons against whom the complaint is there or against whom the alert has been generated. They will seek clarifications. Now, this is the first stage. So, this is the stage from which actually if a client comes to you, you are in a much better position to advise them. And that is what you should educate all your clients, that the moment you get some letter from SEBI, it is generally for some detailed investigation which is being carried out. So they may ask simply what is the change in shareholding pattern over last few years and whether you have given disclosures under Section 29. Maybe this is a small trigger. They may say, okay, I am sending the forms because I have done the compliance, but there may be an investigation on insider trading going on. So any letter coming from SEBI, otherwise SEBI does not write letters to common entities like income tax, writing letters to every small SSC. So any letter coming from SEBI has to be taken seriously by the clients, and they should seek information from you and guidance from you. So not that as a professional, it is expected that you will go and sit with SEBI and check whether what investigation is there. But as prudent professionals, at least we can see whether all compliances that are required to be done have been done thoroughly. Whether the reply that is being filed is being drafted correctly and it is responding to all the things. Third and most important, it is not excessively informative, because at times, because of excessive information or some ridiculous response that a person in his enthusiasm gives, results in a much bigger problem than it is otherwise. So professionals help balancing all these activities and giving the response to the point. So once the communication starts, it has to be taken seriously. Paying a professional is actually cost effective to the client. They to save pittance, but they end up paying pounds when they do it themselves. So that education you will have to your client. Next is that when the designated authority has, they may also call you for summons, or they may summon you for questioning or asking you certain things. These are the powers which are conferred upon the designated authority under SEBI Act. So there is no harm, and before going in even for the summons, it is better to have a dress rehearsal with the customer or the client as to what all are the possible questions that they may ask and what is the line of response. Of course, if we have to ensure that it is the responses are true, correct, and fair. Now that is the least that we can expect. But then all presentations also matter. So you should prefer a dress rehearsal, and I am very particular in using this word because see, it should be a completely professional, that you are maybe the designated authority and you are questioning that client. So what all questions you would pose? Because as professionals, you come across good experience and you can envisage things little better than the end client. And once that is done, it will be little easier for them when they are summoned. Second is, you should also comfort your clients, telling them that whenever you are called for summons, it is not something where you have to get nervous. They are calling for seeking information. And if we come out very clean in that, of course, the investigation aborts. So as professionals, we have to also encourage them not to get nervous and not to mess up with the entire investigation which is going on, because the moment you are nervous, even if you have not done something wrong, the opposite person thinks that, oh no, there may be something wrong. So that confidence has to be given. Next is the designated officer, after detailed investigation, will draft his own report, which I have already said, where there will be recommendations. Now, once the recommendations are done, the case is then passed on. See, SEBI has completely segregation of duties. So the person doing investigation may only recommend action. It is like police. But then police cannot send you to jail for 3 years term saying that you are a guilty person. For that, you have to go to courts. Likewise, the adjudication or the Section 11 proceeding is done by a different person. In fact, he is not even in the entire hierarchy of the investigating team. If one whole-time member is controlling the investigation, that whole-time member will not handle the case of an officer who is under him, because then the independence itself is lost. So it will always go to the another whole-time member or another adjudicating officer. Adjudicating officers, of course, is a completely separate department, but whole-time members have multiple departments. So even if someone has corporate finance department, investigation of CFD are done by his team, the moment his team does it, it will go to some other whole-time member for scrutiny and post showcause notice hearings. So that is how it works, and they try and maintain independence. Once SEBI showcause notice is received, after the DA report, there will be a showcause notice issued to the entities or the notices that are there. Once that is issued, it is the responsibility of the client and the professional to give a suitable response. Now, response broadly, I would suggest for any kind of general showcause notice, there are some standard things that should always be there. It should start from a background as to you have received a showcause notice dated so and so. This is the brief summary. These are the allegations. Because that sets the context. See, when you are representing some customer before a adjudicating authority, don't make him shuffle amongst pages. Okay, now go to showcause notice, now go to my reply, this, that. Prefer that your entire drafting or flow is as smooth as a plain river going. Let it not like waterfalls. So preferred is you start with the background of the show cause notice so that it sets the context when you are representing as well. Next is you should start with the background of your client. See, whatever the background, if she is a housewife, say she is a housewife. If he is a professional, say he is a professional. If he is a layman, say he is a layman. Now that creates a environment as to whom that adjudicating officer or the designated or the whole-time member is dealing with. Now that will help them. See, at times there are some people who are becoming victims. Maybe they have just lent a name for some misdoing. They don't even know they are maybe local panwalas, peons kind of people also come across where their name has been used, but actual culprit is somebody else. There SEBI takes it very leniently. But then if you have never told SEBI that it is this kind of a situation, we cannot expect any kind of sympathy from them. So give a background of the entity whom you are representing. Then you start off again with the violations and the sections that are alleged to have been violated. Then you take give the narrative from your side, like facts of the case. Let's see, in this regard, let us say there is a small front running matter. It is done by somebody, but name has been used or account has been used of somebody else. Then you may start off, yes, housewife, maybe I am a person working in so and so organization. My owner had asked me to open an account with so and so, and I have absolutely no knowledge of the market at all, and whatever and whatnot. And this is an example. See, you may even represent the owner. So your submissions should start with the context, because that has to be in the background when the hearing is going on. Then you should go with each and every allegation. Every allegation has to be replied in detail, and because see, there are provisions of non-traverse. So anything that you either don't reply or you reply evasively is deemed to be have been admitted under the principles of judicial proceedings, not just SEBI. Any court of law, your traverse or denial should be very, very clear and very, very reasoned. If it is neither, means any one of the quality is not there, it is deemed to have been admitted. So you should not fall in the trap of non-traverse. So first line also you can say that nothing contained in the showcause notice shall be deemed to have been admitted on account of non-traverse or otherwise. And then you should go on to discharge your responsibility is to discharge your client from all the allegations that are there. So give detailed explanation to it. Post that, quote the regulations that have been alleged to have been violated, and give your response to each allegation. Now, let us say there is a allegation of violating PF, UTP or prohibition of fraudulent and unfair trade practices regulation of SEBI. So first is you have to test whether your activity is falling under the definition of fraud. So quote the definition of fraud. It is an inclusive definition, but it contains 9 areas. Now explain how your activity does not fall under any of these 9 areas. Then there is section 4 which says even if it is not falling under the definition of fraud, still a following activities from A to T would be fraud. So then explain whatever charge, let us say 4 to E is for price rigging or price manipulation. Explain how your activity was genuine and bona fide, saying that all transactions will have some impact, but whether that impact is bona fide or otherwise is something to be seen, and not whether only there was an impact. Anybody trading in Reliance will also impact price. So simply because there is a price impact does not mean I have manipulated. So explain in detail what your trading pattern is and how you have not violated and why provisions of violation of regulation 4.2e do not apply to you. So this is how the reply should be there. Then there should be proper conclusion. Okay, sorry, I have missed out. Now there is one more very important section called section 15J. Please note the balancing section. It suggests the authority as to what should be the factors to be considered while imposing penalty or taking any action. Now, it has three major things, but there may be several other factors. This is coming from Supreme Court judgment in case of Bhavesh Pabari. Please note down. Right. So SEBI was very stringent, saying that only these three factors have to be considered. So Supreme Court has said, no, it is a proceeding where you have to, where there is application of mind. These three things to be taken into account are just sample factors. You have to take into account all factors relating to that case. Now I will give you that 15J ka three factors which are very critical. First is whether there is any unjust enrichment caused to the noticee. Second is whether any loss has been caused to other investors in the market. Third is whether this is a repetitive act or a one-off instance. Now, I think all three are very self-explanatory points and need not be elaborated by me. So, based on that, you can reply and ask the authority to consider section 15J while taking decision on the action to be taken against the noticing. So this is broadly, and then last there has to be a prayer that no action may be taken. If at all there is no defense and there is some small fault, you may even pray that though there is a technical or venial default on my part, it was not intentional and it may be taken very leniently and no harsh action should be initiated. So this is how a show cause notice has to be replied. Next is after the show cause notice response, you will be called upon for a personal hearing. Now, there is a vast difference between summons and hearing. Summons is something where SEBI is calling you. You means the noticee himself, not someone representative, to question on things that SEBI has in its mind. Hearing is exactly opposite. It is an opportunity to noticee to tell whatever he wants in his defense. Summons has to be attended by the person to whom summons is issued. But in hearing, you may either attend personally, you may choose to send somebody else, or you may go jointly with somebody else. All three options are available. So hearing is your right and SEBI's duty, but summons is SEBI's right and your duty. So this you please remember. Many times clients will say, "Mere saath summons mein bhi chalo." You should explain them that, see sir, they will not allow me inside. I will only be wasting my time sitting in the lobby of SEBI office. Still, if you want, then this is my fee chargeable. And let them take an informed decision. There will be still some clients who will prefer having a, because it gives a lot of comfort when professional is there. So some people may prefer, but then you have told them, yes, this will be situation, because third parties are not allowed when it is being, when someone is being questioned. So this is how things would happen. Now, in the hearing, as a professional, your job is to, one, do a very, very thorough homework and prepare for the case. Don't go overconfident. The moment you think that you know everything of the case, you are 100% bound to fail. Every time you go for a hearing, you have to study very hard. It is much. In school, you have 35% marks passing. Here, you have only 100% or 0. So ensure that you know your case inside out. You know your case laws inside out. You know page numbers, sections, markings. Make your notes. If hearing is for 1 hour, you will require at least 3 days of preparation for that hearing. So when people say that आपको 1 घंटा hearing का 2 लाख क्यों चाहिए, 5 लाख क्यों चाहिए, the answer is I don't go there for 1 hour. I am charging for my homework. Khali muh utha ke chalu kya? You tell me. Then you pay me what you are thinking, what is there in your mind. And if you want me to come prepared, you have to pay for the preparation. So now some important tips for the hearing as well. See, all officials deserve respect, and respect is always mutual. So whenever you are going before any officer, you have to be respectful. Of course, you do not have to be very timid or excessively pleasing them, because that is also not something which is even envisaged, and if a professional is expected to be upright and straightforward. So maintain your dignity, character, but at the same time, ensure that you have pressed upon all your points and try to convince the authority to the best of your capabilities. Once that is done, you may have an opportunity to file a post-hearing submission in case you want to file something extra, that is also permitted. And after that, the SEBI authority would issue an order. So whatever section the proceeding is going on, whether 11 or adjudication. Court proceedings are for prosecution are completely different. They take place in court number 22 in the Bombay court. And for those proceedings, those are very long drawn proceedings, and immediately the bail is to be taken. Those are not that fruitful. It will be take ages for the even the case to come. So that if it comes also, you will require a criminal lawyer, and there are good criminal lawyers who practice this. And if you yourself are a lawyer, it is you may choose to do it yourself. Otherwise, it is better off to ensure that first there is a bail done, and then the further proceedings, like you will get the entire documents for the case, and again you will file a reply. Then representation will be before the judge, saying whether there is any criminal activity done or not done. So this is how the entire proceeding goes about. Now, what we have seen is the possible proceedings which will terminate into an action from SEBI. Now, what we can look into is the settlement proceedings at SEBI. Now, see, all regulators in India are now trying to ensure that their regulatory framework is allowing people. 1 second, I'll just take a break. Yeah. Uh, so there is one proceeding called settlement. There is this regulation called settlement regulations. Now, under that, what you can do is you can choose to settle the case with SEBI. And there is a formula of arriving at the settlement amount. Each section and a violation has its own cost of settlement. And in case the client wants to settle it, you may choose to go in for settlement. Allowing a settlement or otherwise is the prerogative of SEBI. So in case of very grave violation, SEBI may choose not to settle. And otherwise also cost of settlement is far, far higher than the penalties or monetary impact that the client suffers otherwise in a proceeding. So it is a thoughtful decision to be taken. But the better part here is that, see, you may offer, let us say, for a particular show cause notice violations, you may offer, let us say, 8 lakhs. Based on the maths that you have done. There is a lot of flexibility in that. So you take the most optimal for your client. SEBI takes whatever is favorable to them based on the character and conduct of the noticee. So there are factors that if the notice has been deliberately delaying the proceeding, the entire settlement amount will increase by 25%. So there are so many things which are there, which SEBI has lot of discretion on whether to impose those or not impose those, based on which the settlement amount changes. So in the settlement proceeding, you will be called for a meeting, which is before the internal committee of SEBI, IC. Please note down. Now, why I say note down is because, see, when you are talking to your clients also कि अपने पास क्या क्या रास्ता है and what activities we can do, you should be confident कि भाई ये चीजें हैं, and you will be called for a meeting with IC. IC is the internal committee. Because if you yourself are not very confident while talking to your client, no, then he will start searching for other consultants. So that is very important that you know all these words. And please read all the relevant regulations. I will give you few regulations that are not many. And I believe our professional studies was far more voluminous than what I am going to give you. So after this IC meeting, there will be in the IC meeting, there is only a discussion on the amount, because SEBI will come up with its own formula saying that as per as the amount is this much. And there is not too much of a say. Either it is either accept or not accept, or at most negotiate to a particular reasonable extent that you are able to convince the IC. Once internal committee and you agree on a particular settlement terms, within 15 days, you have to give the modified settlement terms that you both have agreed. Once that modified settlement terms are given, it goes to the second level committee. Please note down the name. It is High Power Advisory Committee, HPAC of SEBI. Now, internal committee gives a recommendation that they have proposed an amount of so and so. We also believe that it is adequate to meet the ends of justice and close the matter. And therefore, it will recommend to HPSC. Once HPSC also approves, it will go to two of the whole time members who have to allow the settlement. So then then you will be asked to make payment of the amount. And once you have paid the amount, only after whole time members approval, they will ask for money. Before that, they will not ask for money. And once the approval comes from the whole time member, you will have to make payment within 15 days. And once payment is done, an order of settlement is issued by the whole time members, jointly signed by either a minimum 2 whole time members. So this is how the settlement proceeding goes about. Now you can please note down some of the important regulations where there will be violations. One is the prohibition of fraudulent and unfair trade practices, PFUTP regulation, generally known as. Second is insider trading regulations. Now, these two are the most serious violations. So, anybody who is alleged to have violated either of these two, that is very serious. Then you will have violations with regards to SAST, or Substantial Acquisition and Takeover Code, where there may be a disclosure violation, or there may be a violation of not giving an open offer in spite of breaching a particular limit of holding and all that. So those are not the violations where SEBI presumes mens rea. But whenever there is a mens rea means a guilty mind for taking up a particular act. But whenever there is a charge of PFUTP and insider trading, SEBI presumes there is mens rea. Of course, there may or may not be, and you have to make out your own case. But otherwise, they will not charge you for that. So these two you can say are intention-based regulation. Others may be intention-based or maybe technical in nature. So ICDR you can note down is another regulation which you need to read. But then ICDR is too lengthy. You may prefer to skip that one. As for the timing, if and when the case comes, you can of course read it. So whenever ask the client to send a showcause notice and then go prepared after reading all these regulations. See, under preparation only results in one thing: either the matter not coming to you or compromise on fee. So if you want to be rewarded satisfactorily for all your effort, first comes the effort and then comes the reward. So be well prepared when you are going. If you are not well prepared, then or if you are not able to understand, feel free to speak to consultants, understand things from them, and then go rather than just going and coming back with a poker face. It is not something which is expected of a professional. So these are few regulations that you may prefer to read. And I think this is all that I need to share today about the entire proceedings as to how it happens, where and what the matter lies with, what is the infrastructure institutions hierarchy of handling the proceedings, and what can be the possible consequential outcomes. It also covered how hearing is to be done and reply is to be given. So I think I am through with my side of discussion. Now we can open the entire floor for questioning, and whosoever has question, kindly feel free to ask and I will try to reply to the best of my capability.
Yes, sir. I would like to request the participants to please raise their questions or concern to sir.
Sir, good morning, sir.
Good morning.
Sir, my question is, we have heard about this term called consent orders. So my question is, what are consent orders, and does SEBI have power to pass consent orders?
Abhishek, your voice was not very clear. Can you please repeat?
Sir, my question is, what is a consent order, and does SEBI have power to pass consent orders?
Sir, consent regulation has been replaced with settlement regulation. So what we discussed right now, settlement regulation, was earlier called consent regulation, and orders under that regulation were consent orders. Now those are passed under settlement regulation. So the name is settlement orders.
So we
Thank you,
have
sir.
a question in the chat box.
You may also be subjected to jail.
Okay, what are the consequences of failure to attend the inquiry by noticing? Correct.
So it comes in the summons itself that if you don't take it very
Okay.
seriously and don't accede to what we are wanting, then you may have faced the music. So it is not at all advisable. Don't even think of not doing it, except for a case where you are capable of running away like Lalit Modi and all those people.
Okay, so one more question is there. Which one is better, settlement proceedings or summary settlement scheme?
Sorry?
Which one is better, settlement proceedings or summary settlement scheme?
See, there is nothing called as summary settlement scheme. It is not an open scheme which is available. At times, there are large actions which are to be taken against large number of people. So at that time, SEBI comes up with special schemes of settlement. Right now, the scheme for option settlement is going on, where they are offering only small amount of 1 lakh to some higher amounts for settlement. So those are special schemes which are brought in by SEBI just to ensure that, one, there is lesser hardship to public, and second is their bandwidth is not choked. So because right now 14,750 people are subjected to options wala showcause notice. So if SEBI calls everyone for hearing, issues orders and all, it will be very cumbersome. So SAT has in fact advised SEBI to come up with a settlement scheme. So they had come earlier with a settlement scheme which started up from 5 lakhs. Now they have reduced that amount to 1 lakh. So these are special schemes which are not running and available for everybody and anybody. These are for special events and special cases which whenever they come, it is better off going for those lower amount of settlement and closing the matters.
Correct, sir. So there is one more question from Ms. Lakshita. What is the limitation period for filing settlement application?
60 days.
60 days. Okay. Can settlement application be filed for repeated defaults?
No. See, you can file I think one settlement application in 3 years, that is what is the max you can do.
Okay. So there is one more question.
But show cause of action or show cause notice is one which contains multiple violations. Then you can file a settlement application. So if you have continuing default, let us say you have not filed 29(2) disclosure for purchase, then you sold, that time also you failed. So those are two instances. But if both are a part of one show cause notice or even two show cause notices are issued, you can file one common settlement and close it. But okay, one proceeding has been completed, tomorrow new show cause notice comes, again you file settlement, third show cause notice comes, again you file settlement. That is not something which is envisaged. It is not for fugitive or repetitive offenders.
So the confusion is that if there are 3 or 4 show cause notices, you can file one single application.
If the cause of action is same, see, your job is to file. If SEBI rejects, you will see the rejection. It makes no difference. But then you can try and file, but file one common application for all violations that are open.
Okay. Sir, there is one more question. Please advise what is the first thing to do when anyone receives the query from SEBI?
Seek professional help because that is what comes to the benefit at the end of the case.
I think one should try to, reply as soon as possible to
I
avoid
don't
the
think
question.
so. You should take your own time, do your study, and then reply. See, there is no fun in it. It is not a race that you have to reach first. You have to take reasonable time, do your study, see what is to be replied, and then give. You may seek extensions. SEBI gives reasonable extensions. Please don't shy away from asking extensions, but don't give half-baked, half-cooked answers.
So we can take the extension by filing an application. Do we need to
So
file
you
an
can
application?
write an email. Email ID is good.
Okay. Okay. Sir, one more question is there. Difference between summon and show cause notice more elaborately. Can you explain the difference between a summon?
Summons is something where SEBI wants to question you or seek documents from you. Show cause notice is an opportunity to respond to the allegations that SEBI has levied upon you. So after summons is a part of the investigation. Show cause notice is something which is an outcome of investigation.
So I do have a query in this. Suppose, sir, you have told that summon is to be addressed. I mean, the person on whose name the summon is issued, he or she has to appear before the SEBI, right? Suppose, sir, there is some case where a person is not able to attend due to whatsoever reason. Can he appoint any other person authorized
They
representative?
will allow video, no? What is the difficulty?
Okay.
1 second, madam. Yes, please.
Yes. Sir, the next question is, SEBI recently called for information and issued show cause notice to NSE and its officials seeking explanation on preferential access. Can you please throw some light on this issue?
See, NSE has a primary infrastructure and a fallback infrastructure. All the brokers are supposed to connect at the primary infrastructure. But the fallback infrastructure or the secondary infrastructure was also kept open so that whenever there is an issue in primary, people can connect to secondary. Now the broadcast from the exchange goes sequential. So it will go to first person, second person, third person, fourth person, fifth person, that way. And broadcast is done from both primary as well as secondary constantly at same speed. So some members were deliberately connecting to secondary servers. And there they were taking undue benefit for their algorithmic trading applications where they were getting feeds. Now on one primary server you have, let us say, 1000 connections, but on secondary server you have only 3. So every third data packet will come to you. So you have a much better footing than other general public at large for executing your algos. So this excessive privilege was allowed to select members, and for that the NSE officials who allowed that privilege or are alleged to have allowed that privilege are being questioned.
Okay. Sir, can you explain about the remedies that is available if a company violates with the settlement order, if it is unable to, pay the penalty or comply with the order, then what is the remedy that is available to that company?
See, now there is no possibility of not complying with a settlement order, because settlement order is issued only after the amount has been paid. Prior to that, SEBI will not issue an order. You may, if demand from SEBI is very high and you are not in a position to pay that settlement amount, you may say, I am not interested in going on for settlement. Let the adjudication proceeding or whatever proceeding is there, let it continue. Settlement is your right, whether you want that amount to be paid, whether you want to pay that amount or no. If it is prohibitive, you don't pay, just forget it. Then the settlement proceeding aborts and the normal proceeding continues. This is how the entire thing works.
Okay.
Now, if at all there are orders from SEBI, be it under any regulation and any section, all the orders are appealable to SAT. So before SAT, you will have to file an appeal, and then if SAT gives you some relief or maybe exonerates you from charges, then that order prevails, except for the case where SEBI prefers to go to Supreme Court and challenge it, which is not a common practice at SEBI, only where they have reasons to believe that SAT has earned and it will have a huge impact by setting a wrong precedence, then SEBI goes. So like in case of some important cases like Sahara and Pan Cards Club and Rakhi Trading and Bhavesh Papari, SEBI has gone to Supreme Court and got the orders in its favor. But those are not, that is not the general practice. So this is how the entire proceeding goes about. Now comes the last question, answer to the question, that what happens if some person prefers to ignore the order of SEBI and not pay, let us say, some penalties levied. Then there are provisions for jail. So enforcement proceeding will be initiated. Your bank accounts will be locked. Then too, if you don't pay, then SEBI will initiate a criminal proceeding. And under that criminal proceeding, you will have to go to jail. So this is what it is, collectible in the form of land revenue. You have no escape. Either you should exonerate yourself or pay the money.
Okay, so it is like you have to adhere with the order, you have to pay the penalty.
Otherwise, there is no fund, no? Simply order, it would not even be worth the paper on which it is printed if people have a choice not to pay.
Correct. Sir, can we produce additional documents during an appeal, or first we need to intimate the SAT?
See, there are Supreme Court judgments where Supreme Court has categorically stated that, see, SAT is the first level appellate body. See, in income tax, you have a much bigger hierarchy. You have income tax appeals, that is Commissioner of Income Tax appeals, then ITAT, then High Court, then Supreme Court. Here, there is the SAT is the first level of appeal. So you have all the opportunity to produce fresh documents. SAT may at times question you that why these were not produced. You give valid reason and use it. See, SAT is very liberal in that, because the Supreme Court itself said that SAT should examine both facts as well as law. And when you have to examine facts, you have to examine facts based on the documents that are available. Maybe that is not available at the time of hearing. Even if it is available, I have forgotten, whatever may be the reason, SAT is very considerate in that. You can give fresh documents. No one will question also why this is given.
Okay, sir, we have a very interesting question in the chat box. As we know, the board of directors and the compliance officer are responsible for putting the SDD in place. But what if the designated persons are not taking it seriously?
They will
Then what
face
are
the
the
music.
penalties will be imposed?
See, if they are lucky, nothing will happen. There is a concept called happy-go-lucky. At times, people do blunders and they just get out. It is their good luck. But if you are otherwise in the shackles of SEBI for whatever reason, good or bad, you have no recourse. See, it is being on right side of law is always right.
Right. So, so one last question is there. In case of a settlement application has already been filed in respect of the show cause notice issued by the adjudicating officer before the scheme was introduced and is pending, should another application be filed? I think no.
No, see that has already been decided. See, once a matter is settled, it is settled forever. You cannot say that okay, पहले 5 लाख वाला settlement scheme था, आज 1 लाख वाला है, तो give me 4 lakh refund. And to that, SAT was very clear. See, this question was put before SAT also because SEBI has come up in options for two settlement scheme. One was very harsh, second was so liberal. So whosoever has availed the first scheme, they are telling हमको second वाला में दो और हमको refund दो. The answer to that was very simple from SAT. Let us say that state government comes with a package for farmers that whatever loans are there, we will waive. Can a farmer who has already repaid the loan say that मेरा पैसा वापस दे दो and now give me waiver? The answer is no. Once settled, it is settled forever.
Right.
So this was the example given by the judge and it was so impressive and so apt.
Sir, one query was missed in the chat box. So that is, can we ask SEBI to disclose documents basis which it has served the SOCOS notice? Means, can
100%.
we ask that?
It is their job and duty. You please note down the case law also in the Price Waterhouse Cooper and recent one, Tikano.
Oh.
Tikano is a Japanese company. So both these cases, Supreme Court has ruled that see, so you are a regulator, you are not that private lala type person. So your job is to remain upfront. So whatever documents you are seized of is and which pertains or is relevant to the show cause notice or the charges being made, even if it is in favor of the person, you will have to provide. See, because your job is not to just amass money by collecting penalties. Your job is to regulate the markets in a fair and reasonable manner. So in your case, you may have certain documents which if given to the noticee, will be exonerated. So it is your job to give it.
Sir, I also have a very small query. So it is relating to PIT regulations. So that, for example, being a designated person, if I convey any information, means any upcoming events information with my immediate relative, and basis that if he or she does trading of shares, and one notice comes from SEBI. So, sir, how can we substantiate that there was no mens rea involved?
No, you cannot. What? There was no mens rea. Not that it is a information which is not available to public. You are in a post where you are getting such information. You are supposed to know the law. So not knowing law cannot fall under the not having mens rea. Of course, you had an intention. Why should SEBI say you did not have an intention?
But means
Nobody
in
will believe you. See, these are very basic things. So even if you say मेरे को पता नहीं था, then face the music.
but sir, how can SEBI prove that this information has been passed by
It is
me
not
to my
required to be
immediate?
proved, madam. You see here, the onus of not having a mens rea is on you.
Right,
How
right.
will you say मेरे को मेरा intention ही नहीं था? Then what was the fun in giving that information? The moment you share that information, it is solely with an intention that somebody transacts. Otherwise, what is the fun? Second is you are duty bound to keep it confidential. It is not that nobody has told you and still they are acting against you. There is a very clear cut in regulation which says that unpublished price sensitive information is to be kept confidential. So for such things, if they allow that, oh, there was no mens rea and therefore liberal, then nobody will give any heed to insider trading regulation.
Then, sir, that designated person along with the immediate relative would be prosecuted, right?
Entire chain, even if it is 10 people chain, all 10 people will be taken to task.
Okay. Thank you. So I must say thank you so much for sharing your practical insights on this topic, sir. It was
Yes,
very
Sriram sir. Yes. Yes, sir.
Sir, I have one query. Is there any time limit within which the SEBI has to serve the showcause notice for the offence committed by the company? Because some showcause notice is issued after a long time. Is there any time limit within which the SEBI has to serve the showcause notice?
Sir, SEBI regulation or act do not give any time limitation. But then there are several judgments where it is recorded that if any law does not stipulate a time, it has to be done in reasonable time. And there are so many judgments where those cases are disposed of by SAT in favor of the appellants solely because there is an inordinate delay. So delay is a very strong ground that has to be taken. Generally, in other laws, it is like income tax and all, it is 7 years from the end of assessment year. So SAT also prefers it to be a reasonable time. But if the investigation like options is which involves 14,000 people and regular communication of show cause notice, settlement direction, this that is done, there SEBI may have a liberal timeline. So today, if you say 2014 ka trades are we are in 2023 for options, nobody will say that it is beyond limitation. But if it is a one-off case, which has happened, let us say a small disclosure is not filed with SEBI. After 10 years, SEBI wakes up and says, oh, this disclosure is not filed. Then you can say it is way beyond the reasonable time limit that would have otherwise been there. And it is a good ground to take up.
Yes, sir. So another one small question, sir. Whether this IRDA appeals against the orders passed by IRDA and PFRDA is appealable before the Securities Appellate Tribunals?
Yes, yes, yes. All three are appealable.
SEBI has vast jurisdiction, I think.
Sorry?
SEBI has vast jurisdiction in other actors.
No, it's not SEBI, no. See, PFRDA and IRDA will issue their own
I'm
orders.
sorry, SAT.
Yeah,
SAT
SAT
has
is a vast jurisdiction. But then what they have done is they have tried to create a specialized bench. See, otherwise what happened, same case every high court, because they don't deal it on a day-to-day basis. See, these are violations which will not come now. Let us say land grab violation cases are there in every city, state, corner, jilla, nagar, everywhere. So judges are well seized of all these laws. But the securities market laws, of course, it is not a rocket science, but solely because there is no vast, you can say, popularity of such kind of violations that every judge will have so many cases. The ministry has preferred to have a concentrated bench which daily hears same cases, so that the learning curve which is developed into them helps them passing better and consistent orders. Otherwise, there will be a very inconsistent view formed throughout the country, because nowhere these kind of cases are being dealt with. And second is, therefore, what they have said is, though there is only one level of first level of appeal and then Supreme Court, they have said that the person has to be a retired judge of High Court, the presiding officer. Then there has to be one judicial member and one technical member. Now these three collectively take decisions. So what happens is, the technical member is someone who is seized of financial markets, having detailed knowledge of how the entire markets work, what is the roles, responsibility of every kind of institution. Second, the judicial member is there. He will also have a lot of experience either in being in courts or maybe being in the judicial department of the government. Third, and the presiding officer is a retired judge of High Court. So all three come with enormous experience. And every day, every judge who comes does not have securities market experience here. But every day he listens to the same kind of cases. He has a lot of practice that are limited. And they act as officers of court. So wherever a new judge wants some guidance, even they arrange for meetings with financial market participants. Now, one of the retired SAT presiding officer, he wanted to see how actually dealing takes place. So he was taken to one of the very large institutional brokers, shown how trading terminals operate, how the trading takes place, what happens actually in the market. So to that level also there may be novice in the markets, but they are far, far experienced when it comes to delivering justice. And therefore, this specialized bench is came.
So which court has the jurisdiction, sir, for the offence
Only
involving
SAT,
imprisonment?
only SAT,
Sessions
and
court
then
in
Supreme
Mumbai
Court.
or
Yes. So NSE, BSE orders, NSDL orders, CDSL orders, PFRDA orders, IRDA orders, all are applicable to SAT. And once SAT has decided, it goes to Supreme Court.
okay, sir. Thank you, sir.
I would request the participants, if they have any more questions, they can ask.
I think, Ankita, we are already getting ahead of the time, and sir must
Yes.
be tired now because he has handled so many queries. So I would request you to give vote of
See,
thanks.
I'm available whatever time my job is to satisfy all questions. Yeah.
I don't think, sir, there are any more questions. You have explained the whole entire topic in such a amazing way. And we really appreciate that you have given so much time for this session. And thank you very much, sir, for such a knowledge enriching session. And we really look forward for having more sessions with you in coming times.
Sure,
Thank
madam.
you,
It will be my privilege to join there. I have one last bit of advice. See, there is a very good saying from Einstein. So he has said that if you can't explain simply, you don't understand it well enough. So, and that is expected of every professional. Don't complicate things for your clients. Keep it as simple that any layman would understand. And that is what I also tried today. That see, of course, you all are very learned professionals, but I tried to keep it as simple as I could have otherwise done. Make things simple for people, and that will ensure that your business flourishes. Comfort the clients on the cases that you are handling, and be straightforward in charging. Don't shy away from charging. Don't give free advices, because everything that comes free has no value. But once a person has made payment, he should feel that he has got the value. So all the best to all professionals who are there here. Best wishes for your career and growth.
Thank you, sir.
Thank you, sir.
Thank you, sir. Thank you, sir. Thank you so much.
Thank you, participants.
Thanks. Bye.
Bye, sir.